Thank you, everybody, for your attendance, and I formally declare the meeting open at 6:01. Thank you. Now, this is a formal meeting of the council, and before we proceed, we have some things that we need to do. The first is the acknowledgement of the traditional owners, and we would like to acknowledge that we are meeting on. Wait a minute, we'll just settle down a bit. I know there's so many people. Okay, we'll just hang on. Just put them along the wall there. And if people who are those standing on the side, there's some available seats here. Please don't be afraid to sit in the front. We don't bite.
We do.
Okay, and if you'd like to just take some seats. Okay, I'm now.
Excuse me, could you please speak up with people in the background here?
Okay, I will speak up as loud as I possibly can. Please, a bit of silence just for a few minutes. We would like to acknowledge we are meeting on Jarrah people country, of which members and elders of the Judja Wurrung community and their forebears have been custodians for many centuries. On this land, the Jarrah people have performed age-old ceremonies of celebration, initiation and renewal. We acknowledge their living culture and their unique role in the life of this region. I just want to move to the safety orientation of this building. There are emergency exits there, and I think behind me, and at this venue, and toilets are also through that way. Yeah, there's men and women's toilets at the back for your convenience. This special meeting has been called to hear public submissions to review the General Law Number 2, Community Amenity and Municipal Places. Only those who made a written submission and who requested to speak will be invited to address council. Each speaker will be allowed 3 minutes to speak in support of their submission. Final consideration of Local Law 2 will occur in 2020. The ordinary meeting of council for the month of December will be held on Tuesday, 17 December 2019 at the Doug Lindsay Recreation Reserve. Any normal council business and public participation time will be conducted at that time. Present at this evening's meeting, we have Councillor Don Henderson, Creswick Councillor John Cottrell, Holcombe Ward Councillor Fiona Robson, Birch Ward, Councillor Greg May, Creswick Ward, Councillor Kate Redwood, Birch Ward, Councillor Neil Newitt, myself, Mayor, and Councillor for Colaban Ward. Our officers here this evening are Mr Evan King, Chief Executive Officer, Mr Bradley Thomas, Director of Community and Corporate Services, Mr Bruce Lucas, Director of Infrastructure and Development Services, and Ms Catherine Toome, Coordinator of Governance and Information. If all councillors would please join me to make a statement of commitment. We councillors of Hepburn Shire declare that we will undertake every occasion to carry out our duties in the best interests of the community, and that our conduct shall maintain the standards of a code of good governance, so that we may faithfully represent and uphold the trust placed in this council by the people of Hepburn Shire. Are there any apologies? No, there are none apologies. Are there any declarations of conflict of interest? There being none, we shall proceed. Now, before we move to officers' reports, I'd like to make a statement, and this may be a little bit long, so please bear with me. As you can see, we have two cameras here, and it relates to recording of meetings. By way of notice and in accordance with Section 13 of Council's meeting procedures, Local Law Number 1, Any person, including any representative of the media, must not operate photographic, audio or video recording equipment or any other recording device at this council meeting without first obtaining the consent of council or the chairperson. Such consent may at any time during the course of the meeting be revoked by council or the chairperson. The Chief Executive Officer must advise the chairperson before the commencement of the meeting of any approval to record the meeting that has been given, and the chairperson must inform those in attendance at the meeting that, subject to any relevant legislative provisions, proceedings will be recorded. The approval to record a meeting is subject to the business of the meeting being able to continue in an orderly and lawful manner and in a way that the rights and responsibilities of all attendees can be appropriately managed. This section does not apply to any member of council staff operating any recording device for the purpose of preparing draft minutes of the meeting, which will be retained for a period of 3 months from the date of the meeting. For the benefit of the public gallery, where consent has been granted to a person for the recording of a council meeting, such video recording should only record the councillors and council officers in attendance and in the conduct of the council meeting. Council advise that whilst all care is taken to maintain your privacy, as a visitor in the public gallery, your presence may be recorded. Where consent has been granted to a person to record the council meeting, that person should obtain prior consent before the imagery of an individual person in the gallery is captured. And I will ask, as each person is asked to speak, whether they agree. Has the Chief Executive Officer provided approval to any person to tonight's council meeting to record the proceedings? Mr. King?
Madam Mayor, we have had one request to record the council meeting.
And does the council consent to this, to the recording of the council meeting?
I move that we allow that meeting to be recorded by the applicant, who's us.
Okay. Is there a seconder, Councillor Fiona Robson? All in favour? Okay, declare it carried. All members of the public present in the gallery are requested to be courteous when addressing council, when speaking in support of their submission, and to direct all comments through the chair. Remain quiet during proceedings. Be respectful towards others present and respecting their rights to their own views. Refrain from verbal abuse or harassment of a councillor, member of staff or other members of the public. Refrain from threats of violence. With a large public gallery in attendance, I wish to advise that in accordance with section 7 of Council's meeting procedures, local law number 1, that members of the public present at a council meeting must not interject the meeting. As the chairperson of this meeting, I can call to order any person who is disruptive or unruly during the meeting. If a member of the public is called to order for improper or disorderly conduct and continues the conduct, they are in breach of local law 1. As the chairperson, I can order a person to leave the council building. If I am of the opinion that disorder in the gallery makes it necessary to adjourn the meeting, I may adjourn the meeting to a later time on the same day or to some later time I think appropriate, up to 7 days later than the time stated in the agenda for the commencement of this meeting. I may ask an authorised officer or member of the proper authority to remove from the council meeting any person who acts in breach of the local law or whom I have ordered to be removed from the gallery. We now move to public submissions under section 223 meeting procedure. In accordance with local law 1, section 5.12, a person given a right to make a submission under 223 of the Act and requests to appear in person or their representative at a council meeting to be heard in support of their submission may do so. The time limit for such hearing will be 3 minutes. All submitters to be heard will be called upon in turn by the Chair to speak. No decision will be made by the Council on any submission received and considered or heard at tonight's meeting. Council will consider all submissions and will consider adoption of local law in early 2020. I now move to officers' reports. Mr. Lucas.
Thank you, Madam Mayor. The purpose of this report is for Council to provide an opportunity for submitters to speak to their submissions in response to the draft. The purpose of the report is for Council to provide an opportunity to submitters to speak to their submission in response to the draft Local Law Number 2 of 2019, Community Amenity and Municipal Places. Councillors, you'll be aware that officers have been working on the draft local law and engaging with stakeholders since earlier this calendar year, and have recently put the draft local law out on public exhibition. We have done this on 2 occasions now, the first expiring or coming to an end on the 2nd of October 2019, and as demonstrated through the attendance in the gallery tonight, councillors are well aware that there is a lot of community interest in this matter, and chose to extend the public exhibition period a second time, which also expired on the 13th of December 2019, last Friday. Councillors, we have received or continued to receive submissions over the weekend and this morning, and we have chosen to accept them and include them in tonight's proceedings. There are 113 submissions received thus far, and 21 of those submitters have chosen or requested to address Council in relation to their submission.
Now, just to let you know that because there are so many people who do wish to speak, we have a bell, and it will ring with half a minute to go, and then we'll ring it again when the person, their 3 minutes is up, and we have to adhere strictly to that 3 minutes to ensure that absolutely everybody who has wanted to speak can have their piece. So I now move to the presentations. I will call first of all for Mr. David Holmgren. Could I simply say, it would be really good if you leave your applause until the end of the night so that everybody is able to have their say just smoothly, and we'll just take it one at a time, because our job here is to actually hear what you have to say and take it into consideration for a determination. So this is a formal council meeting, and all of the rules apply must be adhered to. Mr. Holmgren.
Thank you. My submission focused on the informal management and use of public land as part of a history of self-management and resilience in our communities. This informal use of public land is currently growing due to many factors, including the apparent inability of government, business and even community organisations to do much without debilitating red tape and high overhead costs. Another important driver of informal use of public land is the unfolding climate emergency that Council has formally acknowledged. Other submissions will address the draft law in detail, identifying conflicts with local needs and community culture, state policies and procedures, not to mention sloppy drafting and off-the-shelf templates from overpaid consultants. I want to emphasise how this review provides an opportunity for Hepburn Shire Council to bridge the gulf in our communities between those who see regulation as protecting us from bad actions and those who experience regulation as binding us in pointless red tape. By reducing red tape for residents doing small, sensible stuff, Council could gain support from locals who philosophically reject regulation. By focusing its limited resources on real regulation of larger scale, bank financed commercial development, Council could gain support from those who value regulation. In my submission, I suggested some ways in which it may be possible to regulate activity or not, depending on the scale, context and actors involved, rather than the current one-size-fits-all approach. I'm prepared to contribute a more substantial briefing paper to a community and council working group redrafting a local law from first principles. I ask all councillors and staff to acknowledge the long history of self-organisation and self-regulation in our communities and work to facilitate this essential aspect of any serious effort to address the climate emergency by our communities over the coming decade. Thank you.
Dr. Jones?
By the way, it's Dr. David Holmgren.
Thank you. Thanks.
First of all, before you start, I have to ask, and I needed to ask Dr. Holmgren this, do you mind, do you have any objections to being filmed?
Not at all.
Or recorded?
Thank you. Thanks in advance to the Mayor, the CEO, councillors and council officers for your openness to listen. All language is interpretative. What is perceived as safe and unsafe will change depending on values, ideology and interests. Therefore, there is no objective truth when it comes to terms like safe or unsafe. The only way to achieve fair laws, therefore, is to honour the culture or the cultures of this shire the laws are intended for. We already have strict laws concerning campfires, for example. The proposed local laws, if adopted in their current form, states a person must not, in a municipal place or public place, light a fire unless it is in a barbecue. If adopted, this effectively prohibits campfires and contradicts state laws and federal laws that allow campfires in open air outside of total fire-ban days. More importantly, this particular law attacks both Indigenous and non-Indigenous cultural practices. Another example is salvaging, or what is pejoratively called scavenging in the proposed local laws draft. When contacted about salvaging at the transfer stations, WorkSafe Victoria reported that if you can negotiate with the council to have a safety procedure put in place, then they may determine that it can be done safely and decide to reinstate the process. There are no state laws against salvaging or scavenging in Victoria. Otherwise, the WorkSafe officer would not have suggested this. He is saying that these things can be negotiated, therefore they can be interpreted. From my interpretation, I find that many of the proposed local laws in their current state contravene the Victorian human rights clause on cultural rights. All persons in 19.1, I quote, with a particular cultural background must not be denied the right to enjoy his or her culture, and I assume those who identify other. Campfires are big in my personal cultural realm and my household and my close community. As is community fire garden with neighbours and goats, as is provisioning wild food and firewood, as is gathering in groups to celebrate the seasons and the harvests, as is living and teaching the skills of low carbon economy. My submission raises many points about how the local culture and traditions in Hepburn Shire will be negated if these laws are to be adopted in their current form, and how they will inhibit those of us preparing for climate change.
Thank you.
Thank you.
Thank you, Dr. Jones. Mr. Bernard? Do you have any objections to being recorded?
I'm happy with recording. I think it's a good idea. Dear all, I've lived in this area for nearly 30 years. I'm a builder specializing in energy efficient housing systems and building systems. I have contributed to many community activities, for example, together with friends forming the Hepburn Wind project. I understand that Local Law 2 has expired and have joined with my community to develop new guidelines for this area previously governed by Local Law 2. I'm speaking here today to invite Hepburn Shire Council in joining our communities in developing these guidelines. The Local Law 2 that recently expired came from old ways of thinking. Many people in our communities no longer prescribe to those old ways of thinking, but are actively participating in what some may call the future. This new way of thinking, or future for some, are developing along the lines of engaged communities tackling climate change, pollution, inappropriate supply systems, inappropriate economic systems, inappropriate housing systems, etc. In other words, empowering communities to develop local responses to the challenges ahead. I call for a core working group to be formed consisting of community and Hepburn Shire Council experts to design new local law guidelines, Local Law 2, with input from local area working groups throughout the Shire. I have personally witnessed valuable public land being wasted and overgrown and will endeavour to assist with developing guidelines for appropriate land use, including growing food, providing shelter, and so forth. I have witnessed the growing need for appropriate public housing with no real response from our local government. I will endeavour to incorporate temporary emergency housing development on public land. I'm daily witnessing bushfires occurring throughout Australia, and I'm acutely aware of the high ground fuel load in many of our public spaces, as well as the immediate bush surrounding us. So much gorse, so much wood on the ground. This got to change immediately. And I suggest our communities take charge and begin this clean-up tomorrow. I could go on. I request my ward councillors Kate Redwood and Fiona Robson to support my submission. I request Hepburn Shire Council meets with community representatives as soon as possible following this meeting to discuss the next step. Thank you.
Ms. Tammy Jones?
It's Jonas.
Jonas, apologies. Now, do you object to being filmed or recorded?
No. Thank you to the Council for giving us the opportunity to speak tonight. I speak as a local resident, a farmer, and also the President of the Australian Food Sovereignty Alliance, which is a farmer-led organisation made up of over 700 members nationally, working together towards a food system in which people can collectively determine their own food and agriculture systems. Really? As you know better than I, local laws are enacted across shires in Australia. The stated objectives in our shire include managing risk and nuisance to the community and promoting a healthy and safe environment. We've heard from councillors and council officers over the last few weeks that the law also helps manage council's liability should accidents occur where activities were not regulated, such as while salvaging materials from the tip, grazing animals on public land, planting gardens on nature strips, collecting firewood or foraging, amongst others. Under the Wrongs Act 1958, public authorities are given ample protection from being held liable for negligence. Sections 83 and 84 of the Act clearly protect public authorities by listing strict criteria that a plaintiff must establish to pin legal liability on the public authority. And to date, cases against public authorities have been largely unsuccessful unless the authority has a high level of managerial control over the situation that contains the risk of harm. In other words, the more control a local council assumes over an issue or area, the greater the risk of that council being found in breach of a duty of care. We also draw your attention to the point that WorkSafe responded to us to say that if you can negotiate with the council, you can safely allow salvaging at the tip. We'd also like to highlight the Productivity Commission's recommendations from the Regulation Task Force in 2006 that all levels of government should avoid undue prescription or regulation that is too blunt or disproportionate to the problem. Schedule 8, Section 1D of the Local Government Act provides that a local law must adopt the means of achieving its objectives which appear likely to involve the least burden or the greatest advantage to the community. It also asserts that any local laws enacted by council must be aligned with its own policy objectives. And as you'll hear from many tonight, members of this community have many concerns that local law number 2 is at odds with our declaration of a climate emergency and support for the ZNet program to achieve zero net emissions by 2029. It would inhibit farmers like us and other residents from pursuing our low carbon affordable solutions to things as necessary and common as pumping water around a farm and building garden beds, contradicting our Shire and the state's well-established position to support artisanal agriculture. We recommend the establishment of a working group with representation from the diverse constituencies of our Shire. We propose that the group includes, at a minimum, traditional owners, farmers, landless and homeless, low income, youth and women. And where one exists, that they're nominated from democratically constituted organisations who have a mandate to represent their constituency. Thank you.
I will speak through your applause. If the person does not respond, we will move on because they can't hear it. Mr. O'Mara.
Hello Council, hello community. Thank you for the opportunity to talk. What I want to talk today is about the impact of these laws into the lives of our young people. I'm a local school teacher, a local youth health worker, and I've been involved with Council for 23 years in the development of the Dalesford Community Park, and I see what is going to happen with these laws, or possibly the opportunities we miss to see the wonder that is possible, is that we're going to go against the worldwide trend towards nature-based play, inquiry-based play, and also the unconstructed sense of skateboarding, bike riding, and if these come in, it's just going to put that step behind. And what I'm saying is I want to put that step forward. And that step forward is the inclusion of young people into this process. Our young people bring a creative outlook, wonderful participation, and ideas we haven't even thought of. And I think whatever working group is enacted, I want to advocate that our young people are one of our foremost considerations. And in this, I want to go to the key objective of the Hepburn Shire's Young People website, which states, giving young people the chance to make decisions in their own lives and in their community is the key to developing cohesive community where youth are respected. And I think we must uphold that. And if we don't uphold that, we remove it from our discourse, which is on our website. Now, in this, I think it is vital, rather than to speak of them, that we speak and listen to them. And that involves a whole different process. And I think our working group is the first place to begin. We don't have a youth advisory group at this stage, so I'd say we begin with our local schools. Also, I want to talk about the process of regulating these, and that in relation to our young people. In Section 6, there is no indication of how we will deal with young people in incidents of going against these laws. I think that needs to be clear, it needs to be precise, and it has to come from the voice of young people. In that, our staff need to be trained. How do we deal with young people? How do we communicate with their families around these laws? I just want to close with the idea that this is a beginning. It is a wonderful beginning. and to begin with our young people would be a great place. Thank you.
Mr. Rod Kirby. Mr. Kirby, do you agree to be filmed and recorded?
I guess so, yeah, it doesn't worry me in the least.
I hate to ask this.
Okay, well, I'll just read straight from my submission for the benefit of people in the room that haven't seen it. But after reading the draft of the proposed local laws and having attended the drop-in sessions and meeting afterward at Daylesford Town Hall on December the 3rd, I wish to submit, and actually that's a point I'd like to just make with Council. I've put this submission in as a complaint and an objection. I believe I'm entitled to an acknowledgement of complaint. I haven't received that yet. Can I expect to? So, yeah. Firstly, as someone born and raised in Daylesford and whose family has resided in the area for 6 generations, I wish to point out that the restrictive and totalitarian nature of these new laws is totally repugnant to country people, who have always enjoyed a fair measure of freedom in their lives and lifestyles. These laws can only be described as draconian and un-Australian, and I object strongly to the fact that they are being forced upon us by a city-centric council with an urban mindset in collaboration with a Collins Street, Melbourne law firm, Macquarie Local Government Lawyers. I object strongly to the fact that Local Law Number 2 has been drafted by people with a highly regulated Melbourne background and mindset, as opposed to people with a local/country mindset. This has led to some ridiculous shortcomings in the draft. I object to the fact that these laws will undermine our rights, our liberties, and our freedom as country people and as Australians. Our newly appointed Mayor, ex-Melbourne, has stated in the local press that she would use her position to focus on embedding contemporary governance practices for the council. My concern is that these contemporary governance practices also mean greater powers for enforcement officers, over-the-top and unreasonable fines, a Big Brother-like system of infringement notices, and exorbitant permit costs. Perhaps the increased revenue from this system will make up for Council's claimed shortfall in rates to allow for even greater expansion of the monstrous bureaucracy which is deceptively entitled local government. I object and complain about all the points raised in the above paragraph, but my main point of objection and complaint is that we long-term locals in Daylesford, Hepburn and surrounds are having these draconian measures imposed upon us by a top-down force which is external to our local community. External interferences behind the local laws, such as the Municipal Association of Victoria, the Victorian Local Governance Association and the state government. Local laws should take into account existing use rights and the long-term traditions of local people, paying heed to the rights, liberties and freedoms Australians have enjoyed pursuant to our federal constitution. They should not just be redrafted to suit the whims of tree changers, tourists and new residents. And this is an emerging fourth right. You people need to wake up.
And I'm happy to be filmed. Thanks, Lucia. Yep, I will. Thank you. First of all, thanks for the opportunity to speak to my submission, and I want to speak to 3 different aspects of Local Laws 2. First, Local Laws 4.7, scavenging. I want to use the word salvaging because I see salvaging as a waste minimisation strategy. Salvaging from the tip and from the roadside is widely done by this community, as evidenced by the show of hands at the community meeting. I see that there's a potential for increased salvaging and repurposing waste material in collaboration with the Repair Cafe. The Repair Cafe has actually reduced waste to landfill by 1 tonne in its first year of operation, and that's been supported by the Shire, and we greatly appreciate that. The Environment Protection Authority has developed a diagram of the most to least preferable ways of dealing with the waste stream. Avoidance and reuse are the most preferable, and disposal disposal is the least preferable. Eagle Hawk Recycle Shop has won an award as a community social enterprise in central Victoria near Bendigo. They have a best practice waste to reuse model or example, and their motto is sort, reuse and recycle. So I ask Council to shift in their attitude and language from scavenging to salvaging, and that salvaging is seen as a waste minimisation in keeping with the Environment Protection Authority. And also that the Council develop guidelines for safe salvaging. Second, I'd like to touch on Local Law 2.5, trading at a public place. Farmgate and roadside stalls, these support small local growers. They are the epitome of low food miles, reducing food miles, which is critical to the transition to low carbon living. They encourage children to be part of the family economy, selling eggs, honey, fruit, flowers, etc. And these are explicitly supported by the state government. So I would ask Council to develop guidelines rather than laws for roadside and farmgate sales. Thirdly, the definition of event and public place. Local Law 2 defines definitions and requirements for permits are deterrents to community connectedness and resilience. I'm an active member of the Yandoit, Clydesdale and Franklin Ford Community Planning Group, and we organise regular community gatherings in public places, history and story, fire preparation, welcome to newcomers, CFA fundraising, community markets, etc. Permits are administrative and costly and also mitigate against spontaneous gathering, and therefore they're a deterrent. So I ask the Council revise the definitions of event and public place. And I also ask that Council establish a working group. Thank you very much.
I'm happy to be filmed. That's fine. Okay. Yep. Mayor, councillors, council officers and members of the community. I want to congratulate Hepburn Shire on recently winning the 2019 Premier's Sustainability Award for the ZNet project, a roadmap to becoming the first zero-net emissions shire in Australia. And I want to congratulate you on joining over thousands of councils, states and countries globally in declaring a climate emergency. Hepburn Shire is seen by many in this community and beyond to be a visionary council leading the way towards governance for a healthy, sustainable future. We hope that this process of community consultation will help shape a new set of local laws that will build on this reputation and strengthen our community's ability to feed, house and to protect ourselves in a changing world. But we can't do that with Local Laws Number 2 in its current draft. In speaking to councillors and staff at various meetings, I've been told that these laws haven't really changed. It's just the wording that's been simplified and tidied up a bit. But as we know, the word is what makes a law. And so the wording is very important to the meaning and implication of a law. By changing the wording, you have in fact changed the law. And we'd like to see Council work with the community to redraft the wording so that we're all happy with the law. So there are some examples here of slight wording changes that have dramatically changed the meanings of these laws. The new definition of event now means social gathering, and public place now is anything from a park to a pub to a footy ground or a church hall. Does Council intend to enforce permits to meet your mates at the pub for a drink, to have a birthday party in the park or a family reunion at the lake? No. So please change the wording. The new definition of busking now means to perform for the public with or without collecting money. Will you be fining carol singers for failing to obtain a permit? No. So please change the wording. If the new law states we cannot remove, and this is a quote, remove or change in any way anything on a road, will you fine us for removing a fallen tree or checking the pouch of a dead wallaby? If that is not your intention, please change the wording. The wording across so many of these laws is an inappropriate overreach of council's authority over community life. And if these laws go ahead, I believe that each one of us would be unintentionally breaking a law a week, including your good selves. So we're setting the laws up to be broken rather than honoured, which is not good for governance or community well-being. The laws are so broad they're no longer fair, and that opens up the whole process to discrimination, victimisation, favouritism as council staff interpret which law.
I've already said I will do it 3 times and I won't do it anymore.
So those of you in the front, if you hear the name, can you say it again?
Now, do you agree to be filmed?
I'm very happy being filmed, thank you. Mayor, councillors, executives, community. Hepburn Shire has long been at the forefront of progressive change. We're the first council in Australia to move a motion in support of marriage equality. We're one of only 34 Australian councils to declare a climate emergency. That's just 6% of Australia. In ads for council vacancies this year, it says, and I quote, that CEO Evan King is leading the way to shaping a progressive future for Hepburn Shire Council. It is a selling point for both the council and the community of this shire that we are progressive. Well, just from my first simple reading, the changes to Local Law Number 2 are not conducive to a progressive future. These changes, just from a simple reading, are not demonstrably clarifications or tidying up of the law, but an entire new approach to community regulation. As others have noted, many changes to existing laws will have direct negative impact upon people's lives and well-being. Furthermore, since that first reading, I've become aware that many activities which look like they simply require a permit will never receive a permit. There is no process for it. Since that first reading, I've become aware that vague definitions of terms like event and public place, definitions which one would consider picky or irrelevant, have already led to fines interstate. Since that first reading, I've learned that other councils, truly progressive councils, have addressed safety issues like tip management and planting on nature strips with sensible guidelines and processes which actually encourage these activities. As a citizen, I'm afraid when my government, whether it's local or state or federal, tries to make things safe for me by stopping me doing things instead of helping me to do them safely. I'm afraid when my government doesn't adopt best practice when it can. I'm afraid when I'm told not to worry about vague definitions or clear contradictions. I'm afraid when I read proposed laws and find typos or missing words, logic gaps and references to other undiscoverable laws and legislation. I'm afraid when the government itself appears to be so afraid of litigation or community self-regulation that they'd consider blanketing us all in red tape. And lastly, as a citizen, I'm afraid that when virtually anything I do could be considered a prohibited offence by any council officer who feels like it. Hepburn Shire Council is much, much better than these proposed laws. I implore you to abandon the draft laws as they currently stand and engage the community in devising a series of laws which not only meet the needs and culture of Hepburn Shire community, but set a benchmark for all local governments in Australia in these matters of increasing importance for all of us and for the warming world that we all live in.
Earl James.
Earl James!
I'll move to Laura Simcox. Ms. Laura Simcox.
Give me the town crier, Robbie.
Do you object to being filmed and recorded?
No, I don't. My submission focused strongly on the changes to the local laws and what this meant for committees of management of Crown Land Reserves. I'm currently the Secretary of the Bellardo Hall Committee and the Chairperson of the Eganstown Public Cemetery. Whilst I go through a number of the laws in my submission, it's the final part of my submission I wish to address tonight, and that's the process that's been undertaken by the Hepburn Shire in the review of the local laws. The Local Government Act, Section 111, Section 1115 states that a council must have regard to any guidelines made by the Minister under Section 111A when making laws. The need for more robust and consistent process for local laws was identified in the best practice local laws strategy released by the Minister in December 2008. This resulted in the Guidelines for Local Laws Manual and other resources which are intended to assist councils in Victoria to achieve better practice when considering, making, implementing, enforcing and reviewing their local laws. I've made, which I'd like to table to you, Madam Chairperson, some copies of the Guidelines for Local Laws, an overview for councillors and senior executives, which if someone can pass that up please for the mayor. The 2008 Better Practice Local Law Strategy identified that local government in Victoria was unique amongst Australian jurisdictions in not requiring to undertake robust process akin to a regulatory impact statement as part of the development of subordinate legislation like the local laws process we're going through at the moment. As part of the Better Practices Local Law Strategy, they brought into being the local laws community impact statement. My reading of the process we've gone through thus far in the Shire of Hepburn is we've not followed it. And I'll give an example. The best practice guidelines tell us that notice should be sent to people who are affected by the changes in the review of the local laws. I'm a party to two groups, as I said, who are responsible for Crown Land Management. And unfortunately, we did not receive any notice of this process. I think the process has been very, very lacking, and if the Shire had followed some of the guidelines, then we mightn't all be sitting here feeling disgruntled tonight. Councils that undertake better practice generally have a strong commitment to engaging their communities in a lawmaking process. They recognise the value of genuine consultation.
Thank you. Please sit down.
The name?
No, I will say it, not you.
Well,
Thank
we can't
you.
hear you.
Well, then I said already in the beginning about the applause, so please. No, Miss Deborah Mermaid. Deborah. Sorry, Deborah.
No.
Keep going, Robbie. Do you wish to speak? No. You can speak whenever you like.
I'm not really the state to speak because I actually find the forum very suppressive, if that's even a word. I'm finding it very hard to address such a group of people over such an emotive issue for me, given the circumstances and what seems to be an incredible divide between those that probably do their best to lead us or rule us, for want of a better word, and the us that is here basically beseeching them from the bottom of their hearts really about how easy it is for them to sign off on a law without really understanding the extent of it and having it passed pretty much without us even knowing about it. And I think that evokes in me huge emotion, which I find very hard to keep a grip on at this point. So really, I wanted to second what everyone else has said and what everyone who hasn't said anything would like to say. And if there's anything that anyone would like to say and they haven't had their 3 minutes worth, I would like to donate my, I've finished.
Thank you. Ms. Janet Weekly. Janet Weekly.
I'm fine with being filmed. Hello, Mayor, councillors and the community. I haven't got a neatly presented thing. I've backed it together at the end. I decided a contribution I could make is being aware of the best public policy document I've read in the last couple of decades, and all the supporting frameworks and papers, which I think will give us a framework for engaging the community and working. And that is a thing called the National Disaster Risk Reduction Framework, which was developed in 2019 in collaboration with many groups led by the National Resilience Task Force within the Australian Government Department of Home Affairs. Bear with me, terrible department, but the most radical policy you've ever seen. They've done really well. And basically what it has is then a support document profiling Australia's vulnerability, the interconnected causes and cascading effects of systemic disaster risk by that same department. And then there are further guidance notes that go to questions of governance, how you prioritise, what you decide as strategy. I have a quote here. The choices we make and the things we trade off matter. They inspire our strength and prosperity and affect our vulnerability and resilience, which comes from profiling Australia's vulnerability. Vulnerability isn't understood in this context as individual unique characteristics of the person, but are systemic decisions and choices that have been made over time and across histories and geographies. And what it's saying is that you may bear the consequences of a risk, but not be the person who has made cumulative choices. What these documents do, they only hot off the presses. They came out in October and November, and they're still working on further things. I highly commend them to you, is give decision-making tools. They've been a high-level thing with the CSIRO and this National Resilience Task Force. I was lucky enough to go to a stakeholders meeting in Melbourne about a couple of months ago. I got support for them, that people who are on that National Task Force would support our council if we were looking to do training and work on that. They give you models for decision making, how to involve the community. They talk about there is an urgent need, this is from the document quoted, there is an urgent need to make ambitious, collective and transformative decisions in the face of deepening uncertainty. We need to break from business as usual and aspire towards a systems and values-based mindset to collectively resolve tensions about how best to reduce the causes of these risks. I submit, while we're looking at minor things in our local law, they all go back to issues about how we perceive safety and risk and where you bear the consequences of that. Another example is the Smith Street subdivision. They talk about the design and siting of buildings having regard to safety and the spread of fire. And their answer, which I don't dispute under law, is not applicable. There are no buildings as part of this application. I submit that the system is failing.
Peter Rice? Do you mind? I will chair this meeting.
I'm quite happy to be filmed. Citizens of Hepburn Shire. Local law number 2 draft as currently published should be abandoned in preference to the law which was asserted to in 2009, or otherwise the revision process be given extra time for an extra round of submissions. It is a very sloppy draft. The current draft of local law number 2 as posted, it's ridiculously draconian. At its fundamental roots, it introduced a host of new permits and unmeasured penalties of up to 20 penalty units to a number of matters as listed in a number of local clauses, without specifying any measurable methodology for calculating individual penalties for individual misdemeanors offences, as was clearly specified in the 2000 version. And no appeal rights are specified anywhere. An unmeasured legislative right held by Hepburn Shire to penalise any citizen up to 20 penalty units for any alleged contravention of local law number 2, which must then be paid to the Shire in 28 days from the date of fines issued, without holding a council officer to be able to explicitly account for such process, as appears possible in the current draft, is draconian in itself. Yet as noted in the draft, explicing any right to any person to appeal who may be believed to have caused offence on the current draft makes Hepburn Shire as good as both hanging judge and jury. For example, if the current draft of local law is, as is received council's assent, any simple act on behalf of any person, such as picking wild blackberries on public land, may now carte blanche, if the council sees fit, carry a penalty of 20 penalty units. with the fine issued to that person for payment of 28 days. Any such person has no right to natural justice to appeal the fine. It is not good governance to carte blanche ban harmless activity. I submit the current Hepburn Shire Draft General Local 2 fails its own citizens. What else did I want to say? Good governance must be upheld by Hepburn Shire. Council behove to lead. I submit this draft does not encourage public ownership of matters which council should be encouraging via discussion and connection and empowerment of community instead of licensing behaviours via permit, admonishing and repressing reasonable behaviours which must remain citizens' legal rights and liberties. A spirit of public ownership of and action upon democratic rights, recognition of climate emergency and sustainability is lacking in the leadership of the council if this current draft is any indication of where you guys are at.
I'll speak if that's okay.
Do you mind being
No, I don't. I am a local business operator which includes raising funds through events that benefit the community and have raised significant funds to date in the last 5 years. I'm also a landscape architect, a multidisciplinary professional that likes to work in collaboration with people. I want to talk about 4 items. One, the local laws, the lack of transparency, in my opinion. Community consultation, the definition of event and public place, and actively engaging the community members in redrafting local laws, number 2. I have spoken to David George on the telephone for significant time, and I was somewhat confused at the end of that conversation as to what were the drivers for this change. I attended last week at the community drop-in time. There was nobody here. I understand a council's rationale for that there was an incident occurred. It was not until I posted something on the grapevine that probably 3/4 of this community that are on social media actually understood that there were changes to these laws. I was phone called the next day by council. I was given an opportunity to call David George directly, and my question to council and to this room is, who else received a phone call in this room? Just me? I have read 20 of the submissions to date. I reiterate all of their comments. I reiterate Jen Bray's sentiments about wording equaling law. In my conversation with David George, I spoke to him about the definitions. He was very particular about telling me that these things had been taken out of context. That the in the event specifically would only be governed in the instance that it had a significant impact on the public. 2 things I see there is significant and public. I asked him what the criteria was for significant impact. He could not tell me what the criteria was. I asked if there were any measures of risk or complaints to the council that might have driven these new local laws. And he said, yes, there was. And I asked him what they were. And he said, well, actually, we have a case or a job process, which it would go through, but no, it hasn't been quantified. So again, I'm no more the clearer. My other question, I will speak very quickly to the end, which is my request is that you commit and undertake best practice community consultation and governance, that you establish a working group or steering committee with diverse representation to progress local law 2 in a manner congruent with community needs and opportunities. Publicly identify and communicate the drivers for change, develop guidelines and quantitative measures for dealing with changes to local laws. And as stated by Jen Bray and Mark Dickinson, take heed that now is the time for looking forward, not backwards.
Thank you.
It's Cock, actually. Gillian Trebill Cock. I reiterate the request for a working group. The council establish a working group that is diverse and does include use. My major position, as I've explained to council, is that I have horses, and I've had horses all my life. I've ridden horses into town with a golf stick to play golf. I've ridden them into the lake for a swim. I've ridden horses everywhere, but now, because the land I'm on is zoned rural residential, there's a very serious likelihood that I can't even ride them out the front gate. I definitely can't take, if I do take them out the front gate, it is going to cost, as I've explained to some other people before, 2 penalty units. One penalty unit, for people who don't understand, is $165.22. So for me to take my lead 2 horses, or ride 2 horses out the front gate, it will cost $330 plus $330. That's $660 to take my horse up the road to another paddock where my friends want me to eat their grass. So it also affects other people who want to move their horses from a paddock on one side of the road, such as Kieran Pendergast, across to the other side of the road for his riding school. So I think whoever wrote these laws, and we know it's Macquarie from Collins Street who wrote local laws for councils everywhere, so it is a generic sort of template. Not, as David George said, or someone else, other councillors said, as a response to local complaints. I also want to say, to finish that sentence, so yeah, it's not appropriate for our shire to bring in these draconian horse laws. It does mean I can't ride to the Glen Line Reserve without costing an awful amount of money, and by the time I've incurred so many penalty units, then they can impound my horse, and then I lose my horse just because I want to go for a ride to the Glen Line Reserve. So I request council remove any laws that have been brought in about horses and perhaps change them to being just in the main street of Dalesford, but definitely not Glen Line, as it's not even, it's a one-horse town already. Vehicle repair, if my car breaks down, I can't get my son or anyone to come and save me anymore. And as I mentioned in the previous meeting, if my horse breaks down, I have to call a mechanic. Thank you.
That brings to a conclusion the speakers that have asked to speak. I would like
Excuse me, I asked to speak.
No, you're not permitted to speak.
I am. I was given permission.
Oh.
I have Peter Tyndall.
I'm sorry, I don't have a record of Mr. Tyndall, but okay. Well,
I have an email at home.
No, you
confirming my right to speak.
No, there was no right to speak. There were people who developed an agenda before.
There were some people left off.
I don't have your name down.
The email is from David George.
I don't have any record of your name.
I have a record.
Okay.
What's the difference? Please speak. Excuse me.
Where's the yellow?
Now, I will give you 3 minutes, but you are the last speaker, the absolute last speaker. Is that clear?
I'm happy to be filmed. I observed. Yes. My name is Peter Tyndall. I've lived here since the mid-70s. Regarding draft local law number 2, dangerous and unsightly land. I observe that we're gathered here tonight in the presence of a portrait of our Queen. Recently I've been watching The Crown, the Netflix series. In Series 1, Episode 9, we are party to an exchange of views between the proud old landscape painter Winston Churchill and the young so-called modernist Graham Sutherland, commissioned by members of the Houses of Parliament to paint a portrait of their senior statesman. Churchill mocks the portrait when it is officially presented to him at his 80th birthday celebration in Westminster Hall. It is not how he sees himself and not how he wishes to be seen. Again, I'm referring to the word unsightly in your legislation. Writing to Lord Moran, he describes the work as filthy and malignant. Similar words can be found again in your legislation describing the definition of sightly, unsightly. One of Churchill's Labor critics calls it a beautiful work. A Conservative colleague and friend calls it disgusting. We are talking about subjectivities and who will exercise them. The painting was intended to hang in the Houses of Parliament after Churchill's death, but it had been given to Churchill as a personal gift, and he took it home to Chartwell, where it was never displayed. Within a year, Lady Spencer Churchill oversaw the destruction of the portrait. She had already destroyed earlier portraits of her husband that she disliked, including those by Walter Sickert and Paul Mays. Last night I watched Series 2, Episode 5. The young Lord Altrincham so loves the British monarchy that he is prepared to speak out and risk vilification when he observes that the public, after the humiliations of the Suez debacle, are losing respect for the Crown because of its tradition-bound, out-of-touch relationship with those it oversees and governs. In his own small publication, Altrincham makes his dutiful criticism, and for a while he is indeed pilloried. He offers 6 suggestions, 3 stops and 3 starts. I will offer one of each. I move that the term unsightly be removed from all local laws to be substituted with the term sightseeing, and that sightseeing be represented not as the touristic seeing of this or that sightly place or unsightly object, rather that the term sightseeing be offered to all residents and visitors alike.
Thank you. Thank you. Final speaker, I now would like a mover and seconder to the officer's recommendation that the officer's recommendation is receives and notes the submissions received, resolves to allow each of the submitters who requested to speak in their submission a maximum of 3 minutes to speak in support of their submission, and thank all submitters for their submissions, and confirms that Council will respond in writing to each submission. Move Councillor Robson, Councillor Henderson. Do I have any speakers to the motion? No? Okay, any against the motion? Okay, I move the motion as moved by Councillor Henderson. For a vote, yeah. All in favour? Any opposition? No. I declare the motion carried. I now declare the meeting closed, it being 7:15. So thank you, ladies and gentlemen, for your attendance. What will happen now is that I ask all councillors to remain, and we will need to discuss the way forward. And I thank you all for your honesty and for keeping to the time limits. Thank you very much, ladies and gentlemen.